Go ahead, Mr. Covington.
Good morning, Your Honor.
Good morning, sir.
Defendant has the right to represent himself with the aid of standby counsel. Due to the fact Mr. Wyatt G. Harris is inadequate and ineffective, Strickland versus Washington, Mr. Covington will be deprived of a fair trial, and it's positive that Mr. Harris is prejudiced and biased to his case and thinks that he's already guilty. Marion Covington has not seen exculpatory evidence that he requests in pursuant to Brady versus Maryland, such as body cam footage, ballistic reports, surveillance footage, interview footage from witness and evidentiary transcripts. Mr. Wyatt Harris has tried unprofessional tactics to get me to take a plea deal multiple times when I already put on record several times I'm innocent and I'm going to trial. Mr. Wyatt has been to visit me one time in person, one time on video visit. Neither time did we discuss a trial strategy or a plan, and other than this unwanted plea deal. Mr. Covington has been writing and filing and arguing his own motions and petitions by himself with no help at all from Mr. Wyatt. Defendant Marion Covington is not prepared at all for trial, and Wyatt Harris has fought him and Wyatt Harris has had a falling out of communication. Mr. Covington has fired Mr. Wyatt at least 5 times and put it on record to no avail. Marion Covington has been deprived of a fair trial, and if he's forced to go to trial with Mr. Harris, he is sure that Mr. Harris will not properly fight his case and have his best interests.
Yeah. All right, anything else, Mr. Covington?
Yes, defendant respectfully requests this just court to grant this motion and pursuant to insert defendant's Sixth Amendment rights, and defendant asks that he is provided with the means necessary to view and obtain his exculpatory evidence such as laptop and internet access to help him prepare a defense and a trial strategy. Also, defendant asks for adequate time to prepare for trial.
Did you want to say something, Mr. Harris?
Absolutely, man.
All right.
Let me first give the court an update as to where we are.
Okay.
On Monday afternoon, I went up to the prosecutor's office and asked them to make an offer to Mr. Covington that would have been less than the original offer, which was 23 to 40 on a second-degree murder conviction, plus 2 for the gun, which would mean it'd be a total of 25 years. The prosecutor needed to speak with complainants, and they needed to make some decisions about whether they were going to accept my offer of 18 to 40 plus 2, which would have been 20 years in total. The prosecutor came back to me yesterday at about noon and indicated to me that they were not changing that offer. I went up to the prosecutor's office and said, can I make a counter offer of 20 plus 2? They indicated to me that they would accept my counter offer, but the offer that they would present to this court this morning is 23 plus 2, but they would accept my counter offer if I provided a signed plea form with my counter offer. So I went to the jail yesterday and spoke with Mr. Covington about this counter offer. I gave Mr. Covington some time to do some things that he felt he needed to do between yesterday afternoon at, I don't know, 2:30 to this very moment. I also spoke with Mr. Covington's mother yesterday afternoon, who is in the courtroom and can verify that conversation. And I also spoke, I also called Mr. Covington's father. Did not reach Mr. Covington's father. However, I did reach Mr. Covington's father this morning, and Mr. Covington's father has given his recommendation. Both parents' recommendation is that Mr. Covington should not go to trial. Now, Your Honor, we got a big problem now.
And when you say he shouldn't go to trial, you mean they think he should accept the plea?
Yes, he should accept the counter offer,
okay.
the 20 plus 2. We got a problem now, Judge, because Mr. Covington is now, based on this motion, saying that I am inadequate and ineffective. With those words and with this motion, I cannot possibly represent this man.
Oh, you're gonna represent him.
Well,
You're gonna represent him because this is just another attempt by him to adjourn this trial.
well,
He has filed the most, well, I'll let you finish, but
Yeah. Here's what's gonna happen, Judge. Here's where I'm gonna be. Because if he's saying I'm inadequate and ineffective, I'm gonna sit right here and let whatever happens happen. I'm not making a move because I now have a client who is telling me that I cannot represent him and I'm not capable of representing him.
well, I know you are capable.
Oh, well, I understand the court knows.
I
I think
know
everybody in this room
excellent
understands.
With an excellent reputation.
Oh, I understand
This
that.
is a-
Judge, I've
this-
tried cases
This is,
before.
this is an attempt by him to prevent this trial from going forward. We are not gonna listen to his nonsense. This stuff is, all these motions are frivolous. No, put your hand down, Mr. Covington. I'll let you speak. You let me speak. All right? Anything else, Mr. Harris?
I will
Mr.
tell you-
Harris, would you be willing to be standby counsel
No,
on
Your
this? All right, then we are going ahead with the trial. This is just an attempt by him to stop this trial from going forward. And we are not gonna allow Mr. Covington to run this courtroom. He has filed so many frivolous motions, and you say your attorney wouldn't file them. He has an ethical duty not to file frivolous motions. Every one of your motions was frivolous, including this one. This is an attempt by you to try to stop this trial from going forward. We're not doing that. We are going ahead with the jury. We're gonna bring the jury in here. I want to find for the record that Wyatt Harris has tried a number of trials in front of me. He always represents his client very, very well. And I've signed an order that you could be given the laptop over at the jail. Any of the evidence that we've gone over again and again, that you've been presented with all that evidence. I am denying your motion to proceed pro personam. All right?
Yes.
Anything else we need to take up before we bring the jury in?
Yes, Your Honor.
Okay, go ahead.
Do I have a constitutional right to represent myself? Sixth Amendment. Is that my right?
You cannot represent yourself. You don't know the rules of evidence. You don't know.
Do I
you don't
have
know-
a Sixth
Sir,
Amendment right to
don't
represent myself?
Interrupt me.
Do I have a Sixth Amendment right to represent myself?
You do not have a right to represent yourself when you're not adequate to represent yourself. This is an attempt by you to adjourn the trial, because then we have to go get somebody for you that's a stand-in. It'll take 2 or 3 months. You should have done this a long time ago.
I've been
So
trying. I fired him a month
I'm
ago.
denying you've been doing this all this last week. It hasn't been the whole time. You've also, that's one thing. This is your 4th attorney. You are just trying to stop this trial from going forward. Sir, we're done. Please have a seat. Let's get the jury.
Okay. Force me if you want to. I know my rights.
You're gonna go to trial.
I know my rights.
All right?
Judge, can we have a sidebar?
No, let's get the jury.
Going on